Well, good morning. Welcome to Sunday Morning Coffee with Dr. Childress. I'm going to be addressing a rather serious issue in the family courts having to do with the experiment that's being conducted on parents and children in the family courts by the forensic psychologists without appropriate oversight or review. And that this experiment on human subjects has resulted in the destruction of thousands and thousands of lives in the family courts. So let's get into it. And to begin with, I want to orient everybody to the Belmont Report. This is for the ethical principles and guidelines for the protection of human subjects in research. Now, I've worked in several NIMH major research projects. I'm familiar with the Belmont Report and researching on human subjects. And when I came into the family courts, I was pretty appalled at what's going on over here. But the field is controlled by the forensic psychologists. I'm a lone clinical psychologist in a foreign land, so to speak. And so it's taken me some time to get to this point. I've been focused on the ethical violations to standard 2.01, boundaries of competence, 2.04, bases for scientific and professional judgments, 9.01, bases for assessment, as well as maintaining competence, 2.03, and avoiding harm, 3.04, and failure and duty to protect. So that's, from a clinical perspective, that's been my focus because we have active child abuse and active spousal abuse that's not being diagnosed and not being effectively treated and resolved, and we're not protecting the children. And so I've been more focused on the clinical aspect of it. But I'm at a point now where the larger issues are emerging, which is that for the past 30, 40 years, a group of psychologists has been permitted to conduct an experiment on human subjects in the family courts. And it's an experiment in a quasi-judicial role for doctors. And then they developed this experimental assessment procedure called a forensic custody evaluation. Now they're calling it a parenting plan assessment or evaluation sometimes. That they developed this experimental assessment procedure for their experimental new role. And they did that without any oversight, without any risk benefit, without any review, and they haven't had any review for the last 40 years. The experiment failed miserably. It was ill-conceived from the start, and it was extremely poorly executed, but it was an ill-conceived idea to begin with. They created this new role for themselves of being this quasi-judicial role of assisting the court. We're not clinical psychologists diagnosing and treating. We're assisting the court in its custody decision-making. That was a bad, wrong decision. That's an experiment on human subjects in a new role and in a new assessment procedure. And you don't do that without oversight, with a lot of risk-benefit analysis and things. And there would be procedures we would do on that if it was run through a university. But there was no oversight. There's no IRB review on them. There's no licensing board review. There's no APA review. They were simply allowed to experiment on human subjects. And as a result, the lives of thousands and thousands of children over decades has been destroyed by these forensic psychologists. So let's review what the Belmont Report is. So the Belmont Report came out of World War II. Let me talk about that for a second. The Belmont Report came out of World War II after the Nazi medical experiments. And people got very uncomfortable with experimenting, doing medical experiments on human subjects. So that's the origins of the Belmont Report regarding conducting experiments on human subjects. There are three basic principles. respect for persons, beneficence, and justice. Now, from Google Gemini AI, I just said, what are the three principles of the Belmont Report? Here they are. Respect for persons. This principle recognizes the autonomy of individuals and their right to make their own choices. It also acknowledges that some individuals, such as children or those with cognitive impairments, have diminished autonomy and are entitled to protection. This principle leads to the requirement of informed consent, ensuring that individuals voluntarily agree to participate in research after receiving adequate information. The forensic psychologists failed to inform the courts and the litigant parents that a quasi-judicial role for doctors and a forensic custody evaluation developed for this role are experimental, and that they actually are not, valid procedures, and that they may yield harmful results due to bias in the evaluator and potential misdiagnosis when no formal professional level diagnosis is made. So that's independent of that they had no risk-benefit analysis or approval to conduct an experiment on human subjects in the family courts with their new quasi-judicial role and their new assessment procedure for their new role for them, because they don't want to do therapy. They don't know how to do therapy. And so they wanted to be mini judges. And so they created this new role for themselves of assisting the court. And I'm not doing, clinical time. I'm not diagnosing and treating. I'm assisting the court. Well, that's an experimental role for a doctor, to assist the court in its custody decision making. You should have also provided community care as usual, the diagnostic assessment, along with your new approach, and we could have taken a look at them, and your approach was awful, and it would have stayed with a clinical diagnostic assessment. But you didn't. You gave the courts and these parents only your experimental approach. That's a very bad thing to do when you're experimenting on human subjects. So they failed to inform the court. They failed to inform the litigant parents about the experimental nature of what they're doing and the potential harms or the potential risks involved, which are the risk of bias in the evaluator, cultural bias, personal bias, and that will influence the judgments of the evaluator. And there's no oversight for that. There's no second opinion on the evaluator. So whatever bias they have is coming through their report. And the courts and the litigant parents need to be made aware that this is the opinion of one person who's conducting the evaluation and subject to cultural bias, religious bias, personal biases, countertransference biases. And then the other risk is that if you do not render a diagnosis, the risk for misdiagnosis goes up considerably, which is what happened. They misdiagnosed delusional thought disorders, factitious disorders, child abuse, because they're not looking for any diagnoses. They're not applying diagnostic. And so that's a risk. If you do not apply the diagnostic criteria, then you are risking misdiagnosis. And the courts and the parent litigants should be informed of this risk, and they weren't. So that's a violation to Principle 1 of the Belmont Report for conducting experiments on human subjects. In addition, the parents in the family courts have diminished autonomy in decision-making about their lives and the lives of children due to the court's involvement, and that the parents and children in the family courts warrant and are entitled to additional protections and from the potential exploitation and from potential harm. So this group of people, parents and children in the family courts, because of the court's involvement, because children's diminished autonomy, and because of the parents' diminished autonomy due to the court's involvement, warrant the designation as a special population that are entitled to additional protections if you're going to experiment on them. And the forensic custody evaluators just blew through that. There's no caution, no analysis, no protections provided to this vulnerable population. They just came in and started experimenting on them. Belmont Report, second principle, beneficence. This principle emphasizes the ethical obligation to maximize benefits for participants, for the child and parents, for the court, to maximize benefits for the participants and society while minimizing potential harm. So that's a risk benefit. We have to maximize the benefits and minimize the harm. It involves two general rules: do no harm and maximize possible benefits, and minimize possible harms. Researchers must carefully assess the risks and benefits of their research to strive to achieve a favorable balance. Now, one of the problems, many problems, is they're not even conducting research. They're not getting any outcome measures. They're not doing it. So this would never get through an IRB. The risks are too high. The potential benefits are too low. And there's no data. They're not doing any outcome or any review of what they're doing. So this is just an awful from to begin with. But they came in and started because they could experiment on these parents and children, and they were allowed to. Now, the oversight within our systems, the APA, the licensing boards, AFCZ, need to look at how you allowed these group of people to experiment on human subjects with their experimental quasi-judicial role and their experimental custody, evaluation that they made up for their experimental role. And it failed. It was a complete and total failure. And as a result, so they were harmed. Their lives were destroyed by this failed experiment. The experiment in a quasi-judicial role for doctors is harmful to parents and children. This is from the New York Blue Ribbon Commission on Forensic Custody Evaluation. Finally, in 2021, an outside independent review of this experiment was conducted, and here's what they found. By an 11-9 margin, a majority of commission members favor elimination of forensic custody evaluations entirely, arguing that these reports are biased and harmful to children and lack scientific or legal value. At worst, evaluations can be dangerous. This is a dangerous experiment that's harmful to children being conducted on the parents and children in the family courts. Stop. 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 Stop the experiment. It failed. No. Go back to clinical diagnostic assessments. We need to get a diagnosis of the delusional thought disorder, factitious disorder, or child abuse, so that we can treat it and effectively resolve it. This experiment failed, and it should never have been conducted. Okay, we do not experiment on human subjects without some oversight, and especially on a vulnerable population like parents and children in the family courts. So there's two violations to the very principles of the Belmont Report. Third principle, justice. This principle addresses the fair distribution of the burdens and benefits of research. It implies that participant selection should be equitable and that no particular group should be disproportionately bear the risks of research while others reap the benefits. This principle is particularly relevant in considering vulnerable populations and avoiding exploitation in research. The forensic psychologists obtain all the financial and career status benefits from their experiment, while the parents and children bear all the risks of destroyed lives if it fails. That is not an equitable distribution of risks and benefits. All the benefits go to the researchers, the experimenters, the forensic custody evaluators, financially and in terms of their career status, while all the risks are borne by the parents and children. A clinical diagnostic assessment, standard healthcare, can be completed in 6 to 8 weeks for around $2,500. A forensic custody evaluation, this experiment they're conducting, takes a leisurely 6 to 9 months when the possible diagnosis is child abuse, and costs at a cost between $20,000 to $40,000. That's just financial exploitation of a vulnerable population. They're just balloon up the costs. They take their sweet time in assessing for possible child abuse, and there's no oversight, and they're just allowed to do this, and to the destruction of lives. New York Blue Ribbon Commission. It's harmful, it's dangerous to children, lacks scientific or legal value. We need to eliminate them entirely. Stop the experiment on human subjects. It's a failed experiment. As a result of their failed experiment on human subjects in a quasi-judicial role for doctors using their experimental assessment procedure, the lives of thousands and thousands of parents and their children were irrevocably destroyed. So let's talk about the experiment, this quasi-judicial role for doctors. Here's from the AFCC guidelines for conducting these parent plan evaluations in the family law cases. This is from the AFCC's flagship journal, Family Court Review, and look at the date, 2023. So this is recent. This is their recent discussion of their experimental approach. Parenting plan evaluations are forensic evaluations for use in developing court orders rather than clinical evaluations. So they're acknowledging it's an experimental approach. Forensic evaluations involve the application of knowledge and skills from the mental health professions to the resolution of legal matters, whereas clinical evaluations aid in the diagnosis of psychological disorders for mental health treatment. So we have healthcare on one side, diagnosis and treatment, and we have this experiment in this quasi-judicial role of assisting the court in its legal things. It's an experimental role for doctors that they've developed for themselves. Okay. And so they're acknowledging that these are not part of healthcare. They are not part of standard diagnosis and treatment. Therefore, they are an experimental approach. In some jurisdictions, parenting plan evaluations may be mistakenly referred to as a clinical evaluation in orders of appointment. This is problematic because unlike clinical evaluations, forensic evaluations are performed for the express purpose of assisting the parties in courts in reaching legal determinations that affect the rights and liberties of individuals. That's not the role for a doctor. Okay, what they've defined as the role for a doctor of, helping the court on legal decisions affecting life, that's not the role for a doctor. All doctors are in healthcare, and we diagnose and treat pathology. But they're expressly saying that's not what they do. They're not doctors anymore. They've left the field of healthcare and believe they have this better approach to actual diagnosis and treatment. No, we get a diagnosis, we get a treatment, we fix the problem. And we get a diagnosis within 6 to 8 weeks. We fix the problem within 3 to 6 months. That's what healthcare would do. But they're got this new experiment that they're trying because they believe it's better, but it's not. And they have no data on it. They never did collect data on it. They're just making stuff up. They're just making up whatever they want. So this is from Stahl and Simon, 2013. In their book, Forensic Psychology Consultation in Child Custody Litigation, a handbook for work product review, case preparation, and expert testimony. So this is published by the American Bar Association. So this is like your handbook for their experimental approach. This is their experimental protocol, sort of this is what we're going to experiment on with people. And, oh boy, we just get to do it. Here's what they say. Clinical thinking and the clinical mindset are no longer thought to be an appropriate approach to forensic psychological work. So that means that the whole healthcare model of diagnosis and treatment, they don't think that's appropriate. Well, that's a very interesting personal opinion. However, you're wrong. The healthcare system, diagnosis and treatment of problems of pathology is absolutely appropriate for the diagnosis and treatment of pathology. We need to fix it. And it is totally appropriate. It's your experimental approach that you think you're more objective. There's no objectivity in what you're doing. You're just personal opinions of the individual evaluators. You're making this stuff up. There's no ground foundation for anything you're doing in forensic psychology. You're experimenting on human subjects, on parents and children in the family courts because you want to, because you have an idea. You think it's going to be better. Well, it's not. It's worse, far worse. The forensic psychologists are intentionally withholding diagnostic information from the courts and from the litigant parents for their own financial gain. So they go into this role. They're not diagnosing or treating pathology. I'm not diagnosing. That's a clinical assessment. Well, then you're withholding diagnostic information from the courts, such as whether or not there's a persecutory delusion in a parent, and this is all a persecutory delusion from a parent created in the child. You're withholding that information from the court. You're withholding the information from the court that this is a factitious attachment pathology imposed on the child for secondary gain to the allied parent, factitious disorder. You're withholding that diagnostic information from the court. You're withholding the diagnostic information from the court that this is child psychological abuse of the child because they're creating a delusional thought disorder and factitious. You're withholding this diagnostic information from the court because you think you have a better approach. You're experimenting on the parents and children in the family courts. You need to go back to being doctors and giving the court appropriate, accurate diagnostic information about what's happening in the family. In addition, you are withholding that diagnostic information from the targeted parent and from the targeted parent's attorney. So they now do not have the diagnostic information about delusional thought disorders, factitious disorders, child abuse, or spousal abuse of their client by the allied parent using the child as a weapon. They don't have any of that diagnostic information because you're withholding it from them. So they're not able to press their case with the court about child protection because they don't have the relevant information to do that because you're experimenting on them by withholding that information so that you can be in your quasi-judicial role. Stop it. It's an experiment. It's a failed experiment. It's awful. It's awful in conception. It's awful in implementation. And it violates just all the principles of the Belmont Report for experimenting on human subjects. The forensic psychologists are conducting an experiment on human subjects, children and parents in the family courts, in an experimental quasi-judicial role they made up for themselves with an experimental assessment procedure called a forensic custody evaluation or parenting plan assessment that they made up for their experimental new quasi-judicial role. From Stahl and Simon, 2013. We are providing a detailed discussion of the differences between forensic and clinical psychology. Now, this is between them and the rest of healthcare. All the rest of healthcare. is diagnosis and treatment, and clinical psychology rests in healthcare. But they're doing something different, and they're going to explain that difference between the roles of a forensic professional and the clinical professional, and between forensics thinking and inference making versus clinical thinking and inference making. We strongly disagree with the clinical approach. They strongly disagree with the approach of healthcare. Very interesting, but the role of healthcare and has been established across tens of thousands of years. Okay, it's medicine, it's healthcare, psychiatric disorders. But you disagree with it. Very interesting personal opinion. We strongly disagree with clinical approach, and the purpose of this chapter is to lay out a comprehensive argument in rationale for the use of a scientifically based, empirically driven, and legally informed forensic approach to custody work. And then they go on to just make up stuff, and they create a straw man about what healthcare is and diagnosis and treatment, and they say it's biased because they're not scientific. No, you apply the diagnostic criteria, the DSM-5. That's like science. Okay, healthcare is diagnosis and treatment, and that's grounded in empirical science. Okay, it's your stuff that is just made up. Parental alienation, resist refuse dynamic. You're just making up pathologies. No, it's just, but they admit that they're doing something different. They're not doing established healthcare. From Simon and Stahl, 2020, second edition of their book, they say, as a formal and organized field, forensic psychology has entered its adolescence, but is far from mature. This illustrates the reality that as an organized field and as an organized systematic approach to behavioral science, forensic psychology remains in its formative years. So that's 2020, just a couple of years ago, after 40 years of doing this experiment. It remains in its formative years. They don't even know what they're doing. They're allowed to experiment on human subjects, children and parents in the family courts, with their quasi-judicial role and their made-up assessment procedure for that. And they're still making it up in 2020. It's still in its formative years. Unbelievable. They are experimenting on human subjects, the children and parents in the family courts, with a new quasi-judicial role for doctors that they created for themselves. Who approved this experiment on human subjects? How often was the development of this experiment, that's still in its formative years, how often was the development of this experiment on human subjects, the parents and the children in the family courts, reviewed? The answer is no one ever reviewed it. No, there was no risk-benefit analysis conducted. There was no approval for it. They just did it, and well, I guess they got tacit approval from the AFCC, tacit approval from the APA, tacit approval from the licensing boards. No one's stopping them from doing it. No one's questioning them about what to do, what they're doing with experimenting on human subjects. Where's the APA? Saying, wait. If you're going to conduct this new experiment on human subjects where you don't diagnose or treat pathology, and you're going to be some sort of helping the court decide on custody in this new quasi-judicial role, we need to do a risk-benefit analysis on that. And you cannot withhold standard practice as usual. Okay, don't do that. So you give the families and the courts a clinical diagnostic assessment. Oh, but if you do that, that's 6 to 8 weeks, $2,500, you get a diagnosis of delusional thought disorder, and you fix it. You don't need their forensic custody evaluation. Oh my goodness. So the only reason you are doing their forensic custody evaluation is because you don't have the option of a clinical diagnostic assessment. You don't have the option of standard health care, which they are withholding from you so that they can experiment on you and make lots of money. $20,000 to $40,000 per assessment. And they can just take 6 to 9 months to do it. And it's possible child abuse, but what do they care? It's 6 to 9 months, $20,000 to $40,000. I'm in a quasi-judicial role. From Stahl and Simon, 2020. The forensic role is a non-helper role. So again, they're experimenting. The role of a doctor is always to help your patient, do no harm. That's the role of a doctor. They're leaving the role of being a doctor. They're no longer in a helping role for the person, their client, the patient. They're now in a non-helper role. The evaluating forensic mental health professional is not involved in services that have a goal of alleviation of suffering or discomfort. I find that statement chilling. That their goal is not to alleviate the suffering of the child or the parents. That's not their goal. It's okay with them if the child is suffering. Oh, well, that's not my worry. Oh, the absence of empathy is stunning within the forensic psychologist, just stunning. Arrogance, they're entitled to make up new experiment on people. Grandiosity, they think they're discovering new forms of pathology, parent-child contact problems, and resist-refuse dynamic instead of applying the established knowledge. Absence of empathy. I'm worried that we allowed some very dysfunctional psychologists to experiment on human subjects in the family courts for their own personal needs and gratification and financial gain and stuff, because they like judging parents. That's why they came into the family courts. They don't want to alleviate suffering in people. They want to judge parents as to who deserves to be a parent because of their own countertransference stuff. Who's overseeing this? Where's the training for forensic psychologists in attachment pathology? Nowhere. Where's the training for them in delusional? Nowhere. Where's the training in anything? Nowhere. They're just allowed to experiment on these parents. When the courts appoint a mental health professional to conduct a child custody evaluation and offer advisory recommendations to the court regarding the psychological best interests of the children, the evaluator is, in reality, an agent of the state. Doctors should never be an agent of the state. That's a wrong role for doctors. Doctors diagnose and treat pathology. We do no harm, and we don't get used by the state, okay, somehow. And so this was an ill-conceived role. It was a poorly developed forensic custody evaluation for that role. It's an experiment on human subjects. It needs to end. We need to go back to healthcare, diagnosis and treatment. We need to get an accurate diagnosis 100% of the time for our treatment and for the court's decision making. We're worried about child abuse by one parent or the other. The court needs to know which parent. We need to know which parent for treatment, and we need to fix the problem within 3 to 6 months. I don't want to see these custody evaluations going on for years where we destroy the child's entire life in a custody evaluation or custody battle. So from the Belmont Report, respect for persons. They're in violation of that. Forensic custody evaluations are in violation of Principle 1 of the Belmont Report. The courts and the parents were not informed that a quasi-judicial role for doctors is experimental, and that the forensic custody evaluation developed for this experimental role may not be valid and may be harmful. Belmont Report, beneficence. Number 2, violation. Forensic custody evaluations are harmful to children. New York Blue Ribbon Commission on Forensic Custody Evaluations. 3, justice. Violation of that. The children and parents bear all the risks for destroyed lives, while the forensic psychologists, the experimenters, reap all the financial and career status benefits, the forensic psychologists are financially exploiting a vulnerable population. When we finally got a outside and independent review of this experimental approach, by an 11-9 margin, a majority of commission members favor elimination of forensic custody evaluations entirely, arguing that these reports are biased and harmful to children, lack scientific and legal value. At worst, evaluations can be dangerous. That's New York Blue Ribbon Commission on forensic custody evaluations. Now, the custody evaluators, AFCC, may argue with this and say, oh, no, they're wrong. Well, in the interim, let's stop it, okay? Stop this experiment on human subjects until we get some appropriate eyes on this, to look at the risk benefit, to see if it's actually lacks scientific and legal value, to see if it's actually dangerous to children and harmful to parents, and get some outside independent review on this experiment. That would be like an IRB review in a university setting, but there's no university involved, okay? You're just allowed to do it on your own. So we need to get the APA in here. We need to get the licensing boards in here. We need to get the AFCC in here, although the AFCC is them, okay? So that's a questionable situation when they're producing and generating and running this experiment on human subjects. Well, the legal professionals in the AFCC, you need to take a look at the Belmont Report, and you need to take a look at this experiment, and you need to figure out what's happening relative to the forensic psychologists that you're working with. And maybe we need to eliminate forensic custody. But you know what? Then what happens? Okay, that you don't have any mental health services in the family courts. Oh my goodness. And so because they've withheld the clinical diagnostic assessments from the family courts. So there's all sorts of remediation that kind of needs to start happening with the mental health professionals in the family courts. And you need to acknowledge that you experiment on these parents and children, that you failed in your experiment, and that as a result, we have thousands of destroyed lives. One of the things we need to do is start going out to outreach. Mental health, APA should be doing outreach to the now adult children whose lives were destroyed, and to the parents out of the family courts who lost their children because of this experiment, and start doing some sort of therapy or treatment for their grief and for the destruction of their lives that this unregulated, unmonitored experiment caused. Okay, but we need to acknowledge that there's a failure before we can take the corrective action necessary. And the corrective action is to stop experimenting on human subjects without oversight. So with that, I'm going to head off to my Sunday. Probably can tell I'm kind of feisty about this issue because, again, the Belmont Report was developed off of the Nazi medical experiments. Okay, that's where the principles came from. And so to be violating the principles of the Belmont Report is disturbing. Okay, and then we have the APA Ethics Code Standard 2.01, 2.04, 9.01, 2.03, 3.04, and your professional obligations and duty to protect the child from child abuse, duty to protect the targeted parent from spousal abuse by the allied parent using the child as a weapon, 2, duty to protect. All of that surrounds forensic custody evaluations. We need to change things. So with that, I'm off to the rest of my Sunday of work. Take care, everybody.